record should reflect that the jury is back in the courtroom. Welcome back, folks. I hope you had a good lunch. Before the end of the morning session, the prosecution was still direct examining Dr. Fenton. Doctor, I remind you that you're still under oath. And Mr. Brockler, you may proceed with the rest of your direct examination.
Thank you, Your Honor. Doctor, we were talking about the June 11th, 2012 session that you and Dr. Feinstein had with the defendant. Do you recall that?
I do.
One of the things that you had done is you had gone through all of the questions that you had, you and Dr. Feinstein had asked about stressors that could potentially be affecting him, and you had described for us the answers. Fair?
Yes.
Now, at some point, does the conversation turn to his feelings about you or his concerns about you being afraid of him or something like that?
It does.
Tell us about that.
I'm going to look at my notes here from June 11th. So I'm talking about how he was making some seemingly hostile comments to both Dr. Feinstein and I, and so Dr. Feinstein asked him if he was aware that some of his comments or his demeanor might frighten other people or make other people concerned.
What did he say?
And he said, and I'll quote this from my note. He said, "Well, Fenton is clearly afraid of me. That's why she asked you here to protect her or something. And then that one time she locked the door and had a conspicuous package behind her chair."
Do you know what that's in reference to?
I think I do.
Well, one quick thing. You read that with a certain style. Is that the way he's talking, or is that just the way you're reading it?
He did have, I'd say, a little bit of maybe an angry edge to his voice at that point.
Okay. Tell us about the reference to the locked door. What do you remember about that?
Well, to get into my office, there is a door first that goes from the hallway into a waiting room. So when I come in the morning, I have to unlock that, which is not as simple as it should be. It involves sort of jiggling the inside doorknob. And so if I don't do that, it is locked from the outside. And so every once in a while that will occur. So that occurred on one of his appointments. It was May 1st.
Okay.
And so I had, once it was slightly after the appointment time, I realized that he wasn't there, so I went out to look in the hallway and found the door had been locked.
Does he say anything to you at all during the May 1st visit or up until this moment about the door being locked?
No.
This is the first time he brings it up?
Yes.
Tell us about the package, if you know what that's about.
Well, I don't know for sure, but the chair that I always would sit in during our sessions, a lot of times I would put stuff that I had brought in for the day, which sometimes might include a box of something I had to return or mail off. So I'm thinking that it was something along those lines he saw behind my chair.
Now, after this part of this conversation, did you and Dr. Feinstein discuss with him ongoing therapy after June the 11th?
We recommended that he come for ongoing treatments.
The defendant tell you?
He said, well, no, his insurance was going to expire as he exited the program.
And what did you guys say in response to that?
And we said, well, actually, we're willing to see him for free, so that would not be a barrier.
And how did he respond to the suggestion that it wouldn't cost him anything to continue to have treatment with you and Dr. Feinstein?
Well, then he said he couldn't see a reason to continue treatment if he was not going to be in the grad program anymore.
What did Dr. Feinstein say?
He said, well, what about getting treatment for your life?
And how did the defendant respond to that?
He paused for a few seconds. I thought he was considering the question.
And then?
And then he said, no, he wasn't interested.
And then what happened?
I think it was after that he got up and left, but let me check. Yes, that essentially was the end of the session, and so he said that he needed to go meet with his advisor, and so he stood up and walked out.
Now, the way he left, is that pretty consistent with how he'd left all the other prior appointments he'd made?
Pretty much, yeah. He would just get up and leave.
No, hey, goodbye, handshake, nothing like that?
No.
Okay. In terms of his presentation as he's leaving, is there any significant difference that you can discern between that guy leaving on the 11th and the guy that you met with on March the 21st?
No.
Did he at that meeting ever express to you or Dr. Feinstein any increased detail about a target or a plan to kill people?
No.
Did he tell you that he had purchased a cell phone stun gun?
No.
How about a folding knife?
No.
Shotgun?
No.
Couple handguns?
No.
Talk to you about buying road stars?
No.
And we've already talked. Did he mention to you at this point about the gas mask and the tear gas canisters?
No.
Did he mention to you that he had solidified a plan to attack a movie theater and he bought 2 pairs of handcuffs at that point to use to lock the doors to keep people in so he could increase the body count?
No.
Does he ever express to you that he's depressed?
No.
Suicidal?
No.
Manic?
No.
Do you observe any signs of mania or depression?
No.
Does he ever tell you at any of the sessions you had with him that he is hearing voices?
No.
That he is seeing things like hallucinations?
No.
Does he tell you that he's seeing shadows in his third rotation, in his third lab rotation?
No.
How about flickerings?
No.
Flashes?
No.
Blobs?
No.
Head juggling shadows?
No.
Nothing like that.
Nothing like that.
Does he tell you that he has concerns with his nose?
No.
Concerns with his eyes?
No.
That he's suffering from catatonia?
No.
That he has an odd sense of himself?
No.
That he can't fall asleep?
On the first visit, he mentioned he had occasional insomnia.
After that?
No.
In fact, after that, is the expression about sleep one that he feels tired all the time? Bless you.
He was sleeping about 9 hours a day and still felt tired.
Did he ever express to you that he was it's hard to read. Did he express to you that he had a long-standing hatred of mankind?
He didn't say that in so many words, but that was the sense that I had.
Now listen, he walks out on June the 11th, and you've got the information you've described for us. In your opinion, could you have just grabbed him up off the street and forced him into a cell and put drugs in him?
No.
Why couldn't you have just grabbed him and put him into a hold? What did you need? Bless you.
For a mental health hold and somebody has homicidal thoughts, to qualify for a mental health hold, they need to have a couple of things, and one is evidence that it's not just a thought, but they have a plan. They're moving towards action on those thoughts. And then the second thing is there has to be a specific target. And he all along had denied both of those.
So whatever else was going on in the real world, inside your office, does he ever express to you any of those things?
No.
Is there anything about his presentation that tells you what he's about to do, if he's about to do anything, is imminent?
No.
Is one of the things that you consider whether or not he is, I don't know if the right term is grossly disabled, but he's incapable of caring for himself?
Yes, gravely disabled. Could put somebody on a mental health hold.
And when you evaluated the defendant as he left the office on June the 11th, how did you evaluate him for that?
That was us asking questions about his plans for the future and seeing if they were reasonable and how he was functioning.
And?
He seemed to be functioning well. All the plans he told us about made sense.
Okay. Now, is that it? He leaves on June the 11th and you close your folder and it's over?
No.
What did you do?
So I still had significant concerns about his homicidal thoughts and potential dangerousness, so I took some additional steps.
Tell us about him.
So the first thing I did, other than discussing this with Dr. Feinstein at the end of the session, was I called what's known as our beta team.
What's a beta team?
So it's the Behavioral and Environmental Threat Assessment Team. Most schools have something like this now, and it's a team of campus officials who are there to help anyone who's struggling with what to do with a student who has potentially dangerous behavior.
Now, when you called that group, are you calling them to say be on the lookout for or for some other reason?
Well, the main thing is for me to gather more information so I can assess what to do next.
Information are you looking for?
So I'm looking for a background check to see if there's any past criminal record, see if there's things like concealed weapons permits, if the person has military, especially combat experience, if they've had any altercations at the school or anything else that somebody else knows about that I haven't heard about yet.
Did you get any information back that was other than a clean bill of health?
No.
So did you stop right there or did you keep on going?
I kept going.
What'd you do?
So I really wanted to know more about the timeline of his mental health. So I had been seeing him for a few months and I knew what he'd been telling me, but I still wondered if perhaps the way he was presenting to me was a relatively new change.
Why does that matter?
Because that would be consistent with what I would call a psychotic break. So like the first instance of psychosis in schizophrenia.
Okay, and what'd you find out?
And so to do that, I needed somebody who could tell me what he'd been like for many years, so I thought his mother would be the person to talk to.
Objection, hearsay.
I don't think there's a question. He was about to ask a question. Overruled?
Before you talked to the mother, did you talk to anyone at the school?
I did.
Tell us about that and why you did it.
Objection calls for hearsay.
The question is, did you talk to anyone at the school? She answered yes. Tell us about that and why you did it. So I'm not sure that it's asking for hearsay, but I'll give you a cautionary instruction, doctor. At this point, you can't talk about what someone else said to you, all right? Go ahead.
Did you talk with someone from the school?
I did.
Tell us who you reached out to.
So first I spoke to the head of the whole graduate school and then went and got the information as to who was the head of the neurosciences program. So then I talked to that person who then led me to James's direct advisor in the neuroscience program.
And let me get a couple names. Did you speak with someone named Angie Rivera?
Yes.
Did you speak with someone named Sukumar, big last name?
Vijaya Aragavan, yes, I did.
Okay. And after you spoke with them, had you learned any new information that caused you any greater concern?
No, I felt more confident that this was not a new change in his behavior.
You then reached out to the defendant's mother.
Yes, for the same reason I wanted to know, had his behavior changed recently or had he been like this for a long time?
In the past, had you asked the defendant for permission to talk to other people to find out more about him?
On this visit, Dr. Feinstein and I asked if he would give us permission to talk to someone who knew him, who could speak in his behalf.
And what did the defendant say?
He refused.
You did it anyway.
I did it anyway.
Okay. What did the defendant's mother tell you?
Objection, hearsay.
Mr. Brockler?
Your Honor, it's not going to be offered for the truth of the matter asserted, but why she did or didn't do what happened next.
All right, the objection is overruled. Members of the jury, what the defendant's mother may have said to this witness is not being offered for the truth of the statements that may have been made, for the truth of the content of those statements. They're being offered only for purposes of showing why this witness took or didn't take certain action. So in other words, they're being introduced for the limited purpose of the effect on the listener, the effect on the witness. And you should not consider them for any other purposes. Everyone understand that? Everybody's saying yes. Great. All right, you may proceed.
Thank you, Your Honor. Ma'am, tell us about that conversation.
So I spoke to James's mother, and she said essentially that he had always been like this, meaning very shy and socially awkward, that it had become worse when he was about 10 and they moved from a small town to the larger city of San Diego. And so they took him to see a school counselor, and who helped him adjust to the new school, but she said didn't address any possible underlying psychiatric issues. Then she said that she thought essentially he had some extreme social phobia, and she was always worried about him, wanted to help him, but just wasn't really sure how to do that. I asked her about any other mental health treatment that he had had, and she said, well, they did go for family counseling when he was, I think it was 8th grade, but other than that, had not seen a psychiatrist or had any therapy before.
Now, the fact that you're talking to his mother and she expresses to you that this social awkwardness, anxiety, phobia, whatever the words were that you said, had been going on for quite some time. How did that impact the way you viewed what you had seen in your office on June the 11th?
So I thought it was much less likely that this was a sudden, a new psychotic break, or maybe a substance-related psychosis. He'd been that way for many, many years since he was a child.
Did you take any other additional steps after talking with the defendant's mother?
I might have had some follow-up phone calls with some beta team members just to say, you know, here's what I found out. Looks like he's been like this for a long time.
Okay. Can we talk now about, you typed up a report after this session.
I did.
And the things that we've talked about over this, right before lunch and afterwards, is that all stuff that's contained in your report?
It is.
I want you to go to page 4 of your report, if you would.
Got it.
Now, there are things that you go through here. This form, by the way, does it appear on a computer, or do you free type this? How does it work?
Well, some of both. This is from one of our electronic health record systems, and there's a template for the note. So a lot of it's free typed, but the stuff on page 4 is they're largely things where I can choose from a menu to describe things like his appearance.
Well, let's do that. Let's
Okay.
just go through that list.
Okay.
For appearance, what did you indicate?
I have well-groomed.
Did he ever, at any of the times that you saw him over those almost 3 months, ever seem to you to not be well-groomed?
No.
What's the next thing there?
Next thing is attitude.
Tell us what you put there and why.
I put contemptuous, devaluing, evasive, guarded, hostile, suspicious, and uncooperative. Why? Because I thought that's how he appeared to me. That's what his actions seemed to indicate.
let me clarify, is that just for June the 11th, or is this sort of an overall characterization of how he's presented to you over that period of time?
This is specific for June 11th, although some of them would apply to other times.
Which ones would apply to other times?
Well, I think probably the evasive and guarded. I think the uncooperative, meaning just that I felt he wasn't very forthcoming with talking with either me or Dr. Feinstein. Those are the main ones.
How about psychomotor?
Psychomotor, so that's, is the person moving around a lot or less? And so I just put psychomotor normal for that.
Did you ever observe him making any weird physical gestures or pointing and sticking in a certain way or anything like that?
No.
How about mood?
Mood is basically how the patient would describe their own mood, and so that says okay.
How about affect?
Affect, I have anxiety, hostility, inappropriate, odd, and bizarre.
Anxiety, was that consistent from March through June?
Yes.
Hostility, what did you mean by that?
Well, he seemed to be not interested in treatment that Dr. Feinstein and I were offering, and just some of his remarks, it felt like he didn't want to come for treatment with us, and he didn't like us.
How about inappropriate?
Inappropriate would be, for instance, I was surprised that he wasn't upset that he had just failed this very important exam. So he seemed calm and relaxed, and I thought that was sort of inappropriate to the situation.
You have a mark here that says odd/bizarre. What do you mean by that?
And that is referring to some of those strange statements that he would make that I just really wouldn't understand. So at this visit, for instance, the ones where, well, Fenton is clearly afraid of you, that's why she brought you here to protect you or something. And there was a time she locked me out and then had that suspicious or conspicuous package, I think it said, behind her chair.
And that's what you meant by checking the box for odd, bizarre?
Yes.
Let me ask you this. In terms of the communication that you had with him, when the defendant would answer you, did he answer you in, I guess, complete and coherent sentences, or would he ever just stop talking in the middle of a sentence, or did you ever, do you know what I mean?
Mm-hmm. Well, he would usually give a very short answer. So it might just be a phrase. It wouldn't necessarily be a full sentence. But it made sense. It wasn't garbled or anything like that.
Okay. You never asked him how he was doing and he said rainbow or something like that?
No, nothing like that.
Okay. How about thought process? I'm sorry. I screwed up, ma'am. Speech.
Speech. So I have taciturn, stilted. So this is just, again, restating that he hardly would talk. It almost seemed like he was trying not to talk. And when he would say things, sometimes it was sort of that a little awkward and stiff.
Thought process.
And I put intermittently odd and hard to follow.
Does that go with the odd and bizarre thing you just told us, or is that different?
It is, and really it's not that I can't see his thoughts. I'm inferring this from the statements he makes, and so sometimes he would make these odd statements. I thought they were odd. I didn't understand them, and to the degree that reflected the thoughts behind it, then I thought his thought process was that way too.
Was the philosophy of life part of that thing when he mentioned to you, hey, you tell me your philosophy of life?
Well, that was in a prior visit. I think it was April 17th, but that would be the type of thing that I would not know what to make of.
Okay. How about thought content?
So here I have paranoid delusions and preoccupations. So again, this is me trying to sort of guess what's in his head, and I put paranoid delusions because of the statement where he said, well, Fenton's afraid of me, she locked me out, and then she had this conspicuous package, and I knew that was, well, he didn't, those were not based on sort of reality, and so I thought those were on the paranoid side.
Okay. Perceptual.
Perceptual, I have denies hallucinations, but does glance about the room in an odd way.
What does that mean?
Well, he had kind of an odd type of eye contact. He would, mostly it was poor, so he wouldn't look me in the eye or Dr. Feinstein that much. Sometimes he would briefly. And then he would tend to look away, and sometimes he also looked like he was kind of looking around the room. I don't know why.
While he was talking or thinking or?
Both while he was talking and sometimes when he was listening to us.
Level of consciousness.
Full. That just means he was alert, he wasn't sleepy.
Orientation.
Intact, oriented times 4. So he knew who he was, where he was, what the date was.
Never expressed to you that you thought he was somebody else.
No.
Memory.
Was intact.
And then for violent thoughts you put?
Homicidal thoughts.
Unchanged at all from when he first talked to you about them back in March 21st?
As far as we could tell.
Under problems, there's something called MHP, nursing dangerousness. What's that?
I can't remember what the MHP means. It might be mental health problems. It's under the listing of problems. But in any case, it says dangerousness and then says homicidal intent.
What does that mean?
So this is another one of those things where there's just some limited choices. So certainly a problem that I wanted to highlight was that he had, or he was telling us he had these homicidal thoughts. And so if a choice had been homicidal thoughts, I would have put that. The closest thing they had was homicidal intent, which to me it wasn't quite accurate.
What's different about it?
Well, intent would be that somebody, to me, that would say somebody probably has a target and a plan, and I never heard about either of those.
Okay, when you get down to, it says axis, Roman numeral 1 to 5. First, is that using the old DSM-4 scale, the Diagnostic Statistical Manual IV or 4 or whatever it is?
Yes, we don't have the 5 axes diagnosis in our new current system.
Now, when you're doing this, why are you filling these things out? Do you have a hard diagnosis, or are you just thinking these are some things that are out there? I mean, how did you fill this out?
So I am putting to the best of my knowledge what I think his likely diagnosis is. And then if I'm considering something but don't have enough information, then I might put R/O, which means rule out. So I'm considering it.
What things did you consider here?
So I was considering Asperger's syndrome.
What is that?
And so that's a high-functioning autism condition where the person has issues with social interactions and relating to people, but otherwise their intelligence and their language skills are fine.
Okay, what else?
Also, I have rule out schizophreniform disorder.
Now, are either of these things conclusions that you've made, or?
Those are both rule out, so I'm suspicious that he might have those, but I just don't have enough information.
And axis 2?
And then axis 2 is where we used to code personality disorders, and so I have schizoid personality disorder.
Had you earlier thought that it was possible it was schizotypal personality disorder?
He had some elements of both schizotypal and schizoid personality disorders. And so some visits, he looked more like an extreme loner type, which would be the schizoid personality disorder, and at other times he looked more sort of odd and quirky, which would be the schizotypal.
Have a moment, Your Honor.
Yes.
Doctor,
Yes.
remember all those questions I asked you about things that you didn't hear the defendant say?
About purchasing things or complaining of symptoms?
All of it. Do you remember that?
I think so.
Had the defendant told you that he was purchasing weapons, that he'd settled on the movie theater, that he'd purchased handcuffs, that he had these other thoughts about human capital and killing people could make him more valuable, would you have been in a position to make a different decision than the one you made?
Objection, improper opinion, testimony, speculation.
Overruled.
Go ahead.
I would have had then some information that he didn't just have homicidal thoughts, that he had some sort of plan and some intent to carry out these thoughts. So, yes, I likely would have placed him on a mental health hold and contacted the police.
But he never told you any of that.
No.
No further questions.
Cross-examination, Ms. Brady.
Good afternoon.
Good afternoon.
One thing I'm going to try and do for the jury is put some of these dates into a sequence. The first time that you ever heard of James Holmes was on March 15th of 2012. Is that right?
I think it actually might have been the 16th. It was the day that Margaret Rove. Oh, you are correct, because before Margaret saw him, she was trying to retrieve his phone number, so she sent me an email about that on the 15th, yes.
So on the 15th, March 15th of 2012, Mr. Holmes contacted the University Mental Health Center.
It's the Student Mental Health Center.
And then you and Margaret Rove talked about getting back to him and seeing what it was that you could do for him.
All we talked about at that point was that she couldn't quite hear the phone number on the message, so she was checking with me and to see if I knew what it was, and I did, so I gave it to her.
And James Holmes was the one who reached out to the mental health center, right?
Correct.
What I am going to do is I'm going to show you Defense Exhibit D-TR-62.
Yes, you may.
Dr. Fenton, does that appear to be a calendar of March, April, May, and June of 2012?
Yes, blank calendar.
Is there a pen up there by chance?
Yes.
Can you write your name and today's date just at the top of that first page there, so we'll know that you're the one who wrote on this exhibit?
And today is the
16th of
16th.
June.
Okay.
Yeah, so you just testified that it was March 15th, and you remember, I think you said on direct that that was the Thursday, March 15th, that Mr. Holmes first contacted the mental health center.
Correct.
Can you just write on March 15th there, Why don't we put J.H. Calls Mental Health Center?
Okay, I put J.H. Call Student M.H. Mental Health Center.
Great, thank you. And then you testified that it was the following day, March 16th, that Mr. Holmes came in and saw the social worker Margaret Roth.
Correct.
Can you write that on Friday, March 16th?
I put J.H. sees Margaret Roth.
Great, thank you. Now, you testified earlier, Margaret Roth is a social worker that works there at the center.
Correct.
And is her role to do sort of an intake assessment of students who come in, or in this case of Mr. Holmes?
She does some ongoing treatment, but mostly initial assessments, yes.
And she did do the initial assessment with Mr. Holmes on March 16th.
Correct.
And she sent you an email referring Mr. Holmes to you.
Yes.
And that's when she expressed to you that he was one of the most anxious students or patients she's ever seen?
Yes.
And also that he had thoughts of killing people.
Yes.
So Mr. Holmes, on the very first time he comes to the mental health center, says that he has thoughts of killing people.
Yes.
Okay. Now, you do not see Mr. Holmes on that Friday, March 16th, correct?
Correct.
And you don't see him on Monday, March 19th?
That's when I first hear from him in an email, is Monday, March 19th.
And you guys set up an appointment for Wednesday, March 21st of 2012?
Correct.
So 5 days after he comes to the Student Health Center talking about wanting to kill people, he meets with you?
Correct.
Now, Margaret Roth also tells you when it's in the process of setting up the appointment that you will probably get an email from Mr. Holmes because he's uncomfortable speaking on the phone. Is that correct?
Yes.
And you did, in fact, get an email from him, and that's how you guys set up the appointment, was by email.
Yes.
Now, Margaret Roth also reports, in addition to anxiety and homicidal thoughts, she believes Mr. Holmes might have trichotillomania. Can you explain what that is, please?
It's compulsive pulling of one's hair out.
Did Mr. Holmes complain of any other compulsive or obsessive behaviors?
Well, he said, oh, do you mean to Margaret?
Correct.
He said that after he eats, he has to get right up and walk. There might be something else. I can look at Margaret's note.
Sure, if you want to do that, please. And that's contained in Exhibit 1248.
Yes.
Thank you.
And the question was other symptoms regarding OCD?
Correct.
I don't see anything else in her note.
Okay, and you also count as an obsessive thought the thought about killing people.
Yes,
Mr. Holmes actually said to Ms. Roth, according to her report, that when asked about other symptoms, he did not want to say, because if he did, Ms. Roth would have to report him.
yes,
He also stated that he had anxiety with public speaking.
correct.
He had problems concentrating,
Yes,
problems taking initiative,
yes,
problems trusting other people.
yes,
Ms. Roth stated that she had a hard time interviewing Mr. Holmes because he would just stare and take a long time to answer.
yes,
And he also expressed to Ms. Roth on that very first day that it was very hard for him to go into the mental health center.
yes,
Now, you talked about Mr. Holmes saying that he couldn't describe any more symptoms or else Ms. Roth would have to report him. And Mr. Brockler asked you about procedures that you can take to hospitalize someone, correct?
yes.
Your Honor, if I can approach the witness, please.
Yes.
Doctor, I'm going to show you what's been marked D-TR-63. Doctor, do you recognize what that is?
Not sure, but I think it is something about a mental health hold.
Is that the law which allows you to place someone on a mental health hold in the case of, if you feel that it's necessary?
Looks like it.
And you're familiar with that law and your ability to hospitalize someone if you need to?
I am.
Is what we're talking about commonly called a 72-hour hold or a 72-hour hold and treat?
Yes,
And what it is you can forcefully hospitalize someone if you need to.
you can hospitalize somebody against their will.
And it applies to you because you're a psychiatrist,
Yes,
and it applies to Ms. Roth because she's a social worker.
correct.
And if the mentally ill person appears to be in imminent danger to others or himself, as you stated, you can forcefully hospitalize him.
Yes,
And that is in order to protect the patient and to protect others.
it's in order, a mental health hold is in order to protect the person and others, but also to gain more information about what's going on and to initiate treatment.
Okay. Your Honor, I would move for the admission of D-TR-63.
There an objection? Can I see that? The objection is sustained. You can ask questions about it, but I don't think it's a proper document to be introduced into evidence, so the objection is sustained.
Okay. Thank you, Your Honor. Doctor, just a couple more questions in about that. there is actually that law that you're holding that is what gives you the authority, since you're not a police officer, that's the law that gives you the authority to make someone be hospitalized against their will.
Correct.
Okay. Now, the first meeting that you had with Mr. Holmes, you testified, was on March 21st of 2012.
Yes.
Can you write that on your calendar, please?
I wrote J.H. first visit with L. Fenton.
Thank you. And I think you testified on direct, but if you could tell me again, approximately how long do you think that meeting was?
45, 50 minutes.
Can you write that on that date also, just so we know how long that appointment was?
Okay. I added 45 to 50 minutes.
Great, thank you. Some of your first impressions at that first meeting of Mr. Holmes was that he appeared nervous,
Yes.
and I think you described it as a frozen nervousness. Is that accurate?
Not in those notes, but yes, that is what I thought.
Okay. What do you mean by frozen nervousness?
Well, a lot of people, when they're nervous, they are fidgety or jittery. And other people are very still, and so that's what I meant by a frozen nervousness. He seemed to be still and hardly moving.
Okay. Did you also feel like he had a blank look to him?
I'm not sure about blank. He didn't really show any emotion in his face.
Okay. Is that also called flat affect?
Yes.
Okay. And during your meeting with Mr. Holmes, you took handwritten notes, is that right?
Yes.
And that's what's contained in Exhibit 1248.
Correct.
Do you take them sort of while you're listening? Is it simultaneous with the meeting?
Some of them were. You can see that I have a form with different categories, things like medical illnesses or past medications. So those notes were taken as I was talking to him. Then I have a couple of additional handwritten pages, and those I wrote immediately after the visit.
Okay. And you do note that he talks about his anxiety,
Yes.
and he talks about ruminative thoughts. Can you explain to the jury what that means?
That, to me, means a thought that just keeps coming back in the person's mind, so they're thinking of it over and over.
And those are the thoughts that he has of killing people.
Yes.
You also talked about, with him about breaking up with his girlfriend,
Yes.
and you believe that he appeared sad about that breakup.
He seemed to.
Throughout your meeting, and I think you said this before, he gave brief, sort of stilted answers.
Correct.
He reported that his mood and energy were decreased.
Yes.
And then you said earlier he had occasional insomnia.
Yes.
He felt like he had a decrease in his ability to focus during the past 2 weeks for when you saw him.
Yes, all that seemed, since his girlfriend broke up with him, he was having these difficulties.
Ms. Brady,
Yes, sir.
I apologize for interrupting you.
No
I've been
problem.
handed a note. The jury needs a break, so let's take about a 15-minute break, okay? Please keep all my advisements in mind during the break, folks, and then we'll have you back here in about 15 minutes. Thank you.
It's hot in here. Isn't it hot in here?
Please be seated, everyone. The record should reflect that the jury has stepped out of the courtroom. And Doctor, you can go on break as well. Could you hand me the last exhibit, please? Thank you. All right. I deny the request to admit Exhibit D-TR-63 because it is a copy of a statute, Section 27-65-105. I think it's entirely appropriate for Ms. Brady to ask questions about it, and I allowed her to do that. And if she wants to ask other questions, I will let her do that. But I don't think it's appropriate to admit it into evidence and to have the jury receive a statute as part of the case. And so for that reason, I deny the request. I've been telling the jury that I'm the one who's going to instruct them on the law, and so I don't think it's appropriate to give them any law separate from what I tell them in the instructions that I give them throughout the trial and at the end of the trial. So that's the reason why I denied the request. But Ms. Brady, you can mark it as a court trial exhibit if you wish.
Yes, please.
I also have a note here. I meant to say something about this morning on the hearsay objections. If there's a hearsay objection and the party asking the question and attempting to elicit testimony that has been objected to on hearsay grounds does not believe it's hearsay, then it's up to that attorney to tell me why it's not hearsay. And we saw an example of Mr. Brockler doing that with Dr. Fenton earlier. Before that, this morning, there was an objection to hearsay, and then I think there was a response, excited utterance exception, and I said there was not enough foundation. If I say there's not enough foundation and counsel wants to lay additional foundation, then they may do that. If counsel believes that there is sufficient foundation, then they can ask to approach and we can take it up at the bench. But that's how we should handle those items. And then finally, I meant to mention with respect to P-TR-795, that was the exhibit that Mr. Edson was dealing with in terms of the bank records. And in my ruling, I talked about why I am not allowing anything before May or so, or not allowing things that go back to January. And I think just listening to Dr. Fenton's testimony highlights the point I was trying to make. I think what's relevant is to the extent that anyone is attempting to compare anything, and that's what Mr. Edson seemed to be arguing. I think what's relevant is to compare what may have happened in terms of Mr. Holmes' demeanor, communications, life in general after about March of 2012 versus before March of 2012. And I think that going back to May of 2011 is sufficient and appropriate in terms of that comparison. And I don't think that the people need to go back all the way to January of 2011. I've said before that this case is in significant ways about school and the defendant's school at CU, and that started about the May, June area, April, May, June, the spring of 2011 is when he started making arrangements to come here to look for an apartment, and then eventually ended up moving here. The records for May will show things in April and will reflect transactions and activity in April, and so that's consistent with the rulings I've made in the past in terms of communications that I have allowed dating back to about that time frame, April, May of 2011. So just wanted to supplement the record on those based on, just as I did based on those reasons that I just gave. Is there anything that we should talk about right now on behalf of the people?
No, sir, thank you.
On behalf of the defense?
Your Honor, what court exhibit are we up to? My
Ms.
notes
Robinson?
show that it's CTR 61, but if the prosecution, I know that there were a number of exhibits. That's correct? Okay, thank you.
So we're showing 61 as well, so we're on the same page. So Ms. Nelson, you can retrieve this during the break and you can mark it, and then you can let me know how you've marked it. And when I say this, I'm talking about D-TR-63, okay?
In typical fashion, I said we have nothing further, and it turns out we do, Your Honor. Forgive me, Mr. Edson had something.
Yes, Mr. Edson.
Just going to have just one moment to confirm, counsel.
Yes,
While he does that, Judge, I thought of something too.
yes.
I think perhaps we should give that limiting instruction that the court's been giving about the testimony of experts is to be considered for purposes of the insanity plea. I think that probably applies to Dr. Fenton as well.
Any objection to me giving that instruction?
Well, Your Honor, she has not been endorsed as an expert by either side. She has rendered some opinions without the same expert detail that we got into with the actual endorsed experts. She is much more of a perceiving witness than she is anything else, so I don't know that a limiting instruction is necessary.
But I think Ms. Brady may have a point. I think she has a point because I think the instruction is required in two situations. One is with respect to evidence acquired directly or indirectly for the first time from a communication derived from the defendant's mental processes during the course of a court order examination. And so for that reason, I gave the instruction when Dr. Reed testified and when Dr. Metzner testified. But the instruction, I think, is also required if it is requested by either party with respect to evidence acquired pursuant to Section 16-8-103.6, subsection 2A, that's a small a, of the Colorado Revised Statutes, which governs the waiver of any claim of confidentiality or privilege as to communications made by the defendant to a physician or psychologist in the course of an examination or treatment for such mental condition. So I think arguably the testimony by Dr. Fenton comes within that latter category.
I agree. In light of that, Your Honor, I agree.
Okay, thank you. I appreciate your candor, Mr. Brockler. And I appreciate you reminding me about that, Ms. Brady. I will give that instruction when the jury comes back. Let me just find it. So the instruction will read as follows. The court has admitted the testimony of Dr. Fenton only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. That's the one, right?
Yes, sir.
All right, I will give it. All right, folks, I'll see you back here Mr. Essen, did you have something?
I did, Judge. I don't know if the court wants to take a break or not, but I'll just tell the court we have our next witness is David Bunch. He's a custodian of records witness for 24-hour fitness. I told Ms. Higgs about his testimony. I think she may have a Rule 16 objection. He was endorsed and a report was generated on June 5th. However, we provided discovery earlier than that, and I can provide the dates and we can have that argument now or later. It seems to make sense to have some of that now. I think she's ready to make that argument.
Okay, that's fine.
Your Honor, it's just very brief. We were provided the information with regard to these records. I believe it was on March 5th of this year. As the court knows, that's well after the time that trial started. That was provided through a different witness, through a Daniel Rojas. I do not believe he was endorsed at that time. And then Mr. Bunch himself, who is the witness that is now going to testify to it, we were not provided a report on that until June 2nd of this year, and he was not endorsed until just right, I believe it was June 2nd or 3rd, right around that time, which, as the court knows, is months into this trial process. So they have not been able, and these records are from 2012, so it's not as if these are new records that just came into existence. They have been around for quite some time. So we'd object to the entire testimony as well as the exhibits under Rule 16.
Mr. Edson?
First off, Judge, people would note that we've received expert discovery from the defense as late as April and May of this year. Specifically related to this, here's the dates associated with the documents. There's two documents. One is a usage report, which essentially is a report showing the entry into the 24-hour facility. That was provided to the defense on March 24th of 2015, that accompanied with Daniel Rojas' report. Daniel Rojas is a loss prevention regional manager out of Dallas, Texas, and we provided that report along with that usage detail on March 24th of 2015. The membership document was provided in DVD 180, which was from October of 2012. So the actual documents themselves have previously been provided before we began the trial portion of this case. As far as Mr. Bunch goes, he came about because when we contacted Daniel Rojas to have him testify in this case, we were told that David Bunch is the local contact essentially for 24 Hour Fitness, and he is here local, and that's reflected in the report that he's here out of Inglewood, and that he would be the custodian of records that 24 Hour Fitness would provide us to go about the foundation required for those particular records. All of that is information, he was shown that the reports, and all of that is reflected in the June report. So that's how we get to this point, Judge.
So were there any records that were disclosed to the defense for the first time in March of 2015, or had they all been provided in October of 2012? I'm not following that.
The usage detail, which is, and I can show it to the court if it makes more sense to the court, but the usage detail, which is kind of almost like an Excel spreadsheet showing the number of entries into 24 Hour Fitness, that was provided March 24th, 2015. The membership agreement was provided in October 2012. It was part of the Hotmail DVD, DVD 180.
And what else was provided in October 2012? Was it just a membership agreement?
Yes.
Okay.
Specific to 24 Hour Fitness, yes.
All right.
And Your Honor, just to be clear, it's the usage report that we have the objection to.
Okay. And usage report, you say, both of you are referring to a usage report. Is that a report reflecting when someone may have used a facility?
Yes, Your Honor.
And why did the people get that in March of 2015 as opposed to before then?
Judge, can I have one moment, please?
Yes.
Judge, that's when we contacted Daniel Rojas. I don't have a better answer than that. I can tell the court that the membership agreement was part of the Hotmail account, totally separate, but the actual usage detail, we didn't receive that until our investigator interviewed Mr. Rojas in March.
And did your investigator interview Mr. Rojas in March of this year?
Yes, sir. Let me get...
And then why did you endorse the new person in June of this year?
When we were determining exactly who was going to be the witness, we had every belief that it would be Daniel Rojas. He was the individual we were contacted. He was the area loss prevention manager, and we were under the impression that Mr. Rojas was going to be our witness. Ultimately, when we contacted Mr. Rojas, he provided us with a different name and different email address, which was David Bunch, and basically told us, this guy's local. He's local, so I don't have to travel up here to testify to this. Use this guy.
So Mr. Rojas didn't provide that information in March when your investigator interviewed you?
Correct. He did not.
He didn't say anything about, oh, there would be a better person to testify about the records than me. You should contact this other person.
He told us nothing about any additional person anywhere, let alone here.
All right. And Ms. Higgs, what's the prejudice in terms of the change of one custodian of records versus the other?
Your Honor, it's not just the change of one custodian of records versus the other. It's
well, let's take that question though. What is the prejudice with respect to that aspect of it?
Judge, my objection is to the introduction of the actual customer usage records, and so that's what I'm going to address with the court. Those are records that we did not receive prior to trial. Those are records that we did not have the opportunity to review or discuss with experts or consider in determining how we were going to proceed in this case, or who we were going to endorse, or what witnesses we were going to call, or how we were going to respond to the prosecution's arguments. And this case has been ongoing for some time. These records existed in 2012. These records are from 2012. The prosecution could very well have gotten these records in 2012 or 2013 or 2014. The bottom line is they waited until 2015 to do it. That's a violation of Rule 16, and we object to their omission.
But Mr. Edson said that they were produced in March, so that's more than 3 months ago. So what's the prejudice?
What I just stated, that we didn't have the opportunity prior to trial, prior to doing endorsements, prior to talking to experts, to consider any of this information and include it in our analysis of this case. We did not get it until well after jury selection began, well after basically this trial began.
All right, the objection is overruled. I don't think that there is any prejudice here. First of all, there's no objection to the change of a custodian of record. So that part of it, I don't have to rule on. The objection is with respect to the records. And yes, the records were produced late, but no, it was not because of bad faith on behalf of the prosecution. Given the magnitude of this case, given the thousands of pages of discovery, given the length of this trial, which we're looking at approximately 6 to 8 months, we started in January. Given that the records were produced more than 3 months ago, there's no prejudice here. Frankly, I've been very pleased that so far there have been such few Rule 16 arguments or objections. There really haven't been any Rule 16 issues, which I'm very pleased about. I don't think that it is unusual to have one of these issues come up, given the number of pages that are in discovery, given the number of witnesses involved, given the length of the trial, given the magnitude of the case, given all those things. I don't think it is surprising to have something like this sort of slip through the cracks, if you will. But I don't have an allegation of prosecutorial misconduct in terms of the people doing this on purpose or delaying the disclosure on purpose or anything like that. It seems like this was something that they missed, and they addressed it in March. The documents were provided to the defense. There are 5 attorneys on the defense side of the case, and this is more than 3 months ago that they've had to look at these records and to address the records. March was before a jury was selected. We took 2 weeks off after the jury was selected in this case. So they've had some time off to prepare during that time. There have been times during this trial when a particular attorney will go days, sometimes more than a week, without having a witness. I understand that they have to pay attention still, but there has been plenty of time and plenty of people to address whatever it is that needs to be addressed in these documents that we're talking about from 24-hour fitness. So for all those reasons, the objection is overruled. All right, let's take a break. I'll see you after the break. Thank you.